Alimony, sometimes referred to as spousal support, is the court-ordered allowance that one party pays to the other party for support while they are separated, in the process of getting divorced, or after they are divorced. This video will address questions about how much alimony is awarded and for how long. But to understand that, you need to understand how Utah's alimony laws work. Unlike child support, Utah does not have an arithmetic statutory formula to follow in determining alimony. Each judge in each individual case is given very wide latitude to make his or her own decisions about the appropriate amount and length of alimony. You could take your arguments over alimony before 3 different judges, and in many cases get 3 very different decisions on the subject of alimony for the same couple. That's how much discretion judges have over this. That's not to say that the judges can do whatever they want, however. You should also know that Utah's alimony statute is gender neutral. Husbands and wives can pay and receive alimony. Either the husband or the wife may ask the court for alimony. Alimony may be awarded temporarily while the case is pending and/or for a longer period after the divorce has been granted. To be entitled to alimony, you have to prove need. What does the court consider evidence of need? The court may consider the following and other factors when deciding whether to award alimony: the financial condition and needs of the recipient spouse, the recipient's earning capacity or ability to produce income, the ability of the spouse who would pay to provide support, the length of the marriage, whether the spouse who would receive alimony has custody of minor children requiring support, whether the recipient spouse worked in a business owned or operated by the payor spouse, and whether the recipient spouse directly contributed to any increase in the paying spouse's skill by paying for education or enabling the payor spouse to attend school during the marriage. If one spouse's earning capacity has been greatly enhanced through the efforts of both spouses during the marriage, the court may make a compensating adjustment in dividing the marital property and/or in awarding alimony. The court may consider the fault of the parties in determining whether to award alimony and what the terms of the alimony award will be. Fault, in terms of whether it affects the alimony award, means any of the following, and I'm not using the exact terms in the Utah Code here, but it's to make it easier to understand. Here they are: adultery, physical abuse, causing your spouse or minor children to fear life-threatening harm, and substantially undermining the financial stability of your spouse or the minor children. As a general rule, the court should look to the standard of living existing at the time of separation in determining alimony, but the court may base alimony on the standard of living that existed at the time of trial. In marriages of short duration, when no children have been conceived or born during the marriage, the court may consider the standard of living that existed at the time of the marriage. The court may, under appropriate circumstances, attempt to equalize the parties' respective standards of living. When a marriage of long duration dissolves on the threshold of a major change in the income of one of the spouses due to the collective efforts of both, the court considers that change in dividing the marital property and in determining the amount of alimony. In determining alimony when a marriage of short duration dissolves and no children have been conceived or born during the marriage, the court may consider restoring each party to the condition which existed at the time of the marriage. It is important to remember with alimony that alimony is taxable to the recipient and tax deductible for the alimony payor. Child support is a non-taxable event. There are no tax consequences whatsoever with child support. Make sure that you take taxes into account when determining the alimony award. Understand the amount you'll be receiving or paying net of taxes to ensure it is an amount you can live with. Alimony may not be ordered for a duration longer than the number of years that the marriage existed unless, at any time prior to termination of alimony, the court finds extenuating circumstances that justify the payment of alimony for a longer period of time. Unless a decree of divorce specifically provides otherwise, any order of the court that a party pay alimony to a former spouse automatically terminates upon the ex-spouse's remarriage, death, or cohabitation with another person. Interestingly, if the marriage is annulled, the remarriage that is, and found to be void from the beginning, payment of alimony must resume if the party paying alimony is made a party to the action of annulment and the payor party's rights are determined. The court has continuing jurisdiction to make changes and new orders regarding alimony based on a substantial material change in circumstances not foreseeable at the time of the divorce. The court may not modify alimony or issue a new order for alimony to address needs of the recipient that did not exist at the time the decree was entered unless the court finds extenuating circumstances that justify that action. In determining alimony, the income of any subsequent spouse of the payor may not be considered except as to the subsequent spouse's financial ability to share living expenses and/or if the payor's improper conduct justifies that consideration. If the party ordered to pay alimony fails to do so, the recipient may file a motion asking the court to enforce the alimony order. The court may issue a judgment for past due alimony. The court may also find a party in contempt of court and order the party to pay a fine or serve time in jail. Before an alimony order from another state can be enforced or modified, it must be registered first in Utah. Thank you for watching. I'm Eric Johnson, and we invite you to read our other articles and other resources available on our website.